But here we have Congress 80 years later, in 1964, almost a century later, in 1964, doing it again. Okay? So one of two things must have happened. Well, maybe one of three things. One possibility is that new language was added to the Constitution. Maybe an amendment was added to the Constitution giving Congress this authority. Okay? Another possibility is that Congress is essentially just saying, we don't care what the Supreme Court thinks. We're going to do what we believe is good for this country, irrespective of what the court says the Constitution means. There are some people, maybe critics of Congress, who would argue that that's exactly what Congress does all the time. Congress does. That's not novel for Congress. They just don't care about the Constitution. They just do whatever they want. Right? Another possibility is that maybe the Congress in 1964 thinks, oh, the court way back in 1883 got it wrong. That they really didn't read the Constitution correctly. Any guesses which of those three it might be? Well, we can eliminate them. Certainly we can eliminate the first one. There was no new language added to the Constitution that would give Congress this authority. Okay? So either Congress just doesn't care about the Constitution, or at least it doesn't care what the Supreme Court thinks the Constitution is, or the Congress in 1964 thinks that the court got it wrong way back in 1883. I think it's probably the latter. I think it's that the Congress in 1964 thinks that there really is some basis in the Constitution for doing this, but that way back in 1883 they just didn't see it. Okay? So wouldn't you know it that the constitutionality of this act, where again, this, just to be clear, what Congress is saying in 1964 with respect to this number 2, public accommodations, is that individuals, businesses, that people who own and operate private enterprises that are open to the public cannot discriminate on the basis of race. They can't deny service on the basis of race. Or they can't diminish service on the basis of race. Somehow, operate in a racially discriminatory manner. The Supreme Court or the Congress say under federal law you can't do that. Civil Rights Act of 1964. Wouldn't you know it that it didn't take very long. In fact, the same year, 2 cases come before the Supreme Court that challenges the constitutionality of that legislation. In fact, I have them up here on the screen. Cottonbach versus McClung, a case that came out of the state of Alabama. It involved Ollie's Barbecue. There you see a picture of the restaurant there on the upper right. A barbecue restaurant somewhere in Alabama. I'm not sure what city it was in, but notice where they proudly served 7-Up. Anyway, they refused to serve African Americans. It was common, particularly in the South. And the Heart of Atlanta Motel would not rent rooms to African Americans. So, in both cases, the federal government, in enforcing the provisions of the 1964 Civil Rights Act, imposed penalties on the owners, operators of these establishments, and they sued. By the way, Cottonbach is the name of the Attorney General of the United States at the time. So it's really the United States versus